this morning?
I'm fine, Judge. How are you this morning?
Well, also, thank you for asking.
Judge,
I guess,
can
yes.
can we address a situation? I noticed, did you get the announcements? I did forward them to you.
Say it again for me.
Did you get the announcements? I did forward them to you.
I did. Thank you. Yes, I appreciate it.
And you got all the announcements and the recommendations?
I did. Thank you.
Okay. You see, there's a lot of,
I see.
yeah, so can any way that we could address that? Because if we keep constantly putting, they may be out. And like I said, it kind of making our counters real big because we're still doing it manually and trying to reset them for like on Thursday. That's really gets complicated.
Okay. I know that Judge Law sent a note to both the chief and the jails. So I have not heard back from that, but I imagine that it's because of what's going on in Fulton County. But I'll try to address it. Thank you, Ms. Lewis.
I
I understand
appreciate it.
that. I
Thank
mean,
you.
we have a very large calendar today, and if it'll just roll it over till Thursday. It'll make it an even larger calendar for that day. So I understand the problem. Thank you.
Thank you.
Okay, so I guess it doesn't appear that they're on with us yet, so we'll get started as soon as the jail gets on with us. Oh, okay, Officer Milton, good morning.
Good morning, Your Honor. I have position 25, position 38, and position 19. Position 20 and position 18 are not here.
Okay, and do we know where they are?
I checked the floor, sir, and unable to locate them here. So I don't know if they got released or if they're at Rice Street because I'm unable to log on to Odyssey.
Okay, thank you, Officer Milton. Let's see. Who would you like to start with?
Position
No,
19.
well, I'm not sure we can start because courtroom 2 is not on, and I don't have any of the public defenders on with us.
Oh, all right, be ready
So,
whenever you are.
okay, well, I'm ready as soon as courtroom 2 logs on with us. So I guess we can't really do too much until the attorneys are with us.
Okay,
Okay, thank you, though.
you're welcome. Thank you.
Okay, the court will be on recess until courtroom 2 joins us. We'll get started as soon as they do. Thank everyone for their patience. Ms. Lewis, are you with me?
Yes,
Oh,
sir, I
oh,
am.
okay. I see that they're coming on now. Thank you.
Oh, yeah, they just popped
Good
up.
morning, Judge. We're a little backed up today.
Okay.
Give me at least 1 to 2 more minutes.
All right. Do we have any attorneys in there with you? Good morning, Norris. Hope you're well this morning. Okay. Good morning, Ms. Vigiletti. I have some people that are at ACDC. If you all would like to proceed with them, I'm not sure if you're busy in the courtroom, but you all just let me know what you'd like to do. We do have people at ACDC that are ready, and I believe one of them you have not interviewed, Ms. Vigiletti, that they were able to locate.
And who, can you tell me who that is?
Position number 19, I guess that's Mr. McLean's case, Johnson.
Are you looking?
Right, we apparently.
I'm sorry, Mr. McLean, you're going in and out. I'm not able to understand.
We would love to talk to Ms. Johnson. Also, there's
Also, what?
Alexis Howard. Last name Howard. Give me a mask. I need a mask, please. Well, that's what the lozenge is for, but please give me a mask. Hopefully that will suppress that. Thank you. I got some practice. Mr. Rhodes, would it be possible for you to call 770-842-5471 with regard to last name Howard?
Yes, can you give me that? I got 770-842.
5471.
Yes, I can call. I'll do that now if it's okay with the judge.
Yes, that's fine. Good morning, Mr. Rhodes.
Good morning,
Yes.
Judge.
And Mr. McLean, your regarding your position 18, the announcement was made that from Officer Milton that they were unable to locate Alexis Howard.
Well,
they're not at ACDC. I guess that's what she told me.
we were going yesterday back and forth between the two jails, literally twice. And she's got to
Okay, so
she's got to be somewhere. But Rice Street tells me she is definitely on 5 Northeast ACDC. And ACDC says no.
hear
Do
that,
you have a
Officer?
room number? I'm sorry, you're on. Did they give you a room number?
No, this is with regard to Alexis Howard and Mr. Rhodes. If they don't find her, you don't need to call, because that's the one we're talking about.
Okay,
So can we do, I'm not sure if we can do something to see if we can track her down in ACDC this morning, Officer Milton. Can we try again?
Yes, sir, I will.
Okay, I appreciate it. So we'll try to get with you, Mr. McLean.
You know, it's possible that they could be released, you know.
Right, and that's what Officer Milton was saying earlier, that she might have been released, but she was not able to confirm that.
Right. So, Your Honor, would a breakout room, would an actual Zoom breakout room with Starkia Johnson? We have 2 people named Johnson with similar first names. One starts with an S, one starts with a Z. At first, we wondered if it was the same person with a misspelling, but we believe it is 2 different people.
Well, position number 19, who they were not able to
Do you see Starkia Johnson?
Right. Yes, they have located Miss Johnson, so I believe she's there.
No, we believe that's 2 different people, the Starkia Johnson and the Sarkia Johnson.
Okay. This is Starcia Johnson, position 19, with the year of birth is 1985.
I think both of them have the same month and date of birth. Year, different date.
With the next email, so this is yours.
Right.
Your Honor,
I'm Zarkia Johnson and my birthday is 8/27/1993.
Miss Johnson, have you been working with Rachel Abden?
Yes, and I was supposed to meet with you today.
Yes, ma'am. I'll be representing you this morning. So this is actually position 1 on the add-on calendar.
Okay.
Ms. Johnson has been working with Rachel Abden, who met with her last night and prepped her that I would be working with her this morning.
Okay, and you need to speak with her.
I think we're okay, Miss Johnson, unless you need to talk to me about something. I think we're gonna take a plea today. Is that right?
Yes, I signed the paper last night.
Okay, great. So we're
Okay.
ready to proceed.
All right, thank you. Good morning, Ms. Johnson. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes,
Thank you, ma'am. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down. Thank you, Ms. Johnson. Let's see, Mr. Rhodes, is this your case?
Yes, yes, it is.
You can proceed when you're ready.
Yes, Your Honor, if I may, is it that the court wants what our recommendation is, or is that a plea colloquy that we usually go through for these?
If it is a negotiated plea, what I normally just require is that you tell me what the negotiated plea is, and anything special that you want to tell me. But if it's negotiated, just let me know what the plea is. Will be too.
Absolutely, Your Honor. It's my understanding that this is position number 1 on the add-on calendar, Ms. Zarkia Johnson. And the charge is battery, family violence, and it is a first offense. The state's recommendation is 12 months to serve, credit for time served. We have that she served over 320 days since March 31st of 2023. So essentially it would take on a time served plea.
Okay. Yes, Ms. Vigiletti.
Yes, Judge, Ms. Johnson is prepared to take the plea. The only minor thing that I'll note is that the offer does say credit for time served 320 days. And I think that's probably just a copy and paste error because she has served 325 days as of today. She was arrested on March 31st of last year.
Okay. So just for the paperwork, 12 months to serve, 325 days, credit for time served, 325 days, balance suspended.
Sounds good.
Okay. So for all in agreement, good. Ms. Johnson, it's my understanding that in case 23 CR 001998A, you wish to plead guilty to battery family violence. Is that correct?
Yes,
Are you under the influence of any drugs or alcohol this morning?
no,
You've been represented by counsel. Are you satisfied with their representation?
yes,
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
yes,
Has anyone forced or coerced you to plead guilty?
no.
Okay, I'll accept the plea as negotiated, Ms. Johnson. Good luck to you, ma'am.
Thank you.
You're welcome. Have a good day. Who do we have next?
Next is gonna be position number 2, Mr. Ozine Brown. We've not interviewed him yet. Say what up? We have not interviewed him yet. Your Honor, there's a few clients in here that were not interviewed. So
Okay,
I don't know if you want to give us a few minutes for them to interview their clients or.
I could do.
let's see, you tell me what you would like to do, and I.
At this point in time, Your Honor, I'm just as baffled as you are. Let's go interview. Let's interview Mr. Brown in the corner.
I can move forward with some more people at ACDC while Mr. McLean does some interviews. And then
Okay, that'll be fine.
Okay.
That'll be fine with me. Let's see. I think, Ms. Vigiletti, that we have position 25 that's yours, and position 38 that's yours. That's at ACDC.
Okay, Ms. Wheeler and Ms. Nesbit, I'm prepared with either, this is, Ms. Nesbit in front of us, this is Samaya.
Okay, let's see. And good morning, Ms. Nesbit. What are we doing with Ms. Nesbit this morning?
So because, this is actually Ms. Nesbit's first time before a judge on this case, I'd like to be heard on bond, Judge.
Okay. As far as the arraignment goes, are you going to file a waiver, or would you like me to arraign her?
I can file a waiver.
Okay. So as far as your case at this point goes, Ms. Nesbitt, it will be returned to the division judge and you will get notification of your next hearing date. As far as the bond goes, is this also your case, Mr. Rhodes?
Yes, it is, Judge.
Okay, so if you can tell me what the current bond is and the facts and the recommendation of the state, I'd appreciate it.
Absolutely. Your Honor, give me just one moment as I pull her GCIC.
Judge, may I ask what position we on? I'm sorry.
Position 25, Ms. Nesbitt.
And I will say, Judge, Ms. Nesbitt was initially given a citation for this incident with a court date on it that was rescheduled. And then she was brought in on a bench warrant, so I don't believe she has a bond or a bond has been set in this case because she never had a first appearance.
Okay, so if that's the case, Mr. Rhodes, then if you'll just give me the history, and if you don't have the history, I can ask pretrial. Who do we have on from? Well, I have that she has 4 cycles, all theft cycles, so nothing that's that's violent.
I was cross-referencing that with her GCIC, and what I'm showing is that is in fact accurate. To me, this case is different. I know that this is a battery family violence, so it is not a in her previous history with theft cases. So I'm in favor of a reasonable bond in this case, Your Honor. I would ask for, as it relates to this case, a global bond of 5,000 on all counts.
5,000 good is the request?
Yes, 5,000 good bond on all counts.
Okay, who is the alleged victim and is there a stay away?
One moment, Your Honor.
Yeah, the alleged victim is Cameron Williams, I see. And if there's a stay away, if you could let me know that.
You're gonna ask that she stay away from the victim at this time.
Judge, I'll add that Cameron Williams is here today, as is Ms. Nesbitt's mother, Alexis, so you can see them both on the screen. They're both present today.
Okay. Given that this is her really first offense of this nature, Ms. Vigiletti, what I normally do, I will do it in this case. For the battery family violence, it'll be a $2,000 signature bond through pretrial. For the criminal trespass, 1,000 signature bond through pretrial for each of those counts, which makes it a total of a $4,000 signature bond through pretrial level 1. As far as, is Cameron Williams on the line with me?
Yes, Judge. And
Okay,
if
go
could I
ahead.
very briefly give you some background? So Cameron and Ms. Nesbitt's mother, Alexis, and Ms. Nesbitt have all told me the same story, that the police report stating that Demaya and her boyfriend got into a physical altercation are actually mistaken. There was a woman named Cameron present that night, and apparently when the police arrived, that woman was already gone, and that is the person that had an altercation with Ms. Nesbitt. But the police reports make it seem like it was a family violence altercation with her boyfriend. And I have heard the same story from all 3 of them. And so I just ask you to consider that they are in a relationship. They have 3 kids together. They did not get into any sort of altercation with each other. There's a mistake in the police report, which is part of why we need discovery in this case. So I just ask you to consider that when you're thinking about stay away requirements and requirements for Ms. Nesbitt and Mr. Williams here.
Okay, thank you, Ms. Vigiletti. Mr. Williams is what Ms. Vigiletti tells me correct?
Yes, sir.
Okay, and you want to have contact with Ms. Nesbitt?
Yes, sir.
All right. As such, it will be no further violent contact with Mr. Williams, and no drugs, alcohol, or weapons while out on bond. All right, did you get that, Ms. Vigiletti?
Yes, and if I may, because Ms. Nesbitt is not terribly familiar with our system. Ms. Nesbitt, I just want to tell you, a signature bond means you can sign yourself out, and if you don't show up to court, you owe that money, okay?
Okay.
Okay.
All right.
Ms. Vigilante, do you have any contact information for Ms. Nesbitt?
I do, I have contact information for both Cameron,
Can
her
you-
foster partner, and Alexis, her mom.
Can you just send me whatever contact information? Because I don't know if the case number is incorrect on the calendar or not, but I can't pull her up in Odyssey at all.
Well, first of all, this is a old, she FTA, and it's
Okay.
FTA number. She fell to appear in front of Judge Raw.
Gotcha. Okay.
So the FTA number has to reflect on the paperwork, because that's what she's booked under. It's 23-005289 FTA. That's the
Okay.
FTA number, and the case number is correct.
Okay.
Counter is 23CR004965, which is related to the 23-00529, 89 FTA. So whoever does the bond modification order, you're gonna have to indicate that FTA number on there also.
Okay, Ms. Vigilante, did you get that?
Yeah, Judge, just.
Now, I could type it to you in the chat. if you
Okay,
want.
that would be helpful, thank you. And just to make sure we have the total right, it's 4,000 on the battery and 1,000 on each? I'm sorry,
It's 2,000 on the battery, 1,000 on each of the criminal trespasses, makes it a total of 4,000.
got it, thank you.
Okay, thank you, Ms. Lewis. I appreciate that. And Ms. Nesbitt and Ms. Nesbitt's family, you all have a good rest of your day. Good luck to you, ma'am.
Thank you, too, Your Honor.
Thank you.
Your Honor.
Thank you.
You're welcome.
This is Ms. Wheeler, position 38.
Okay, this is Ms. Wheeler, is that right?
Yes, Your Honor.
Yes, good morning, Ms. Wheeler. Ms. Vigilante, what are we doing with Ms. Wheeler this morning?
Ms. Wheeler would also like to be heard on bond, Judge.
Okay. As far as the arraignment goes, would you like to file a waiver? Or would you like for me to arraign her this morning?
Yes, I can file a waiver.
Okay,
Can y'all please indicate the case number that y'all on, because I didn't hear it.
okay, yes, we're on position number 38, case 24 CR 000631, Kayla Wheeler. Good morning, Ms. Wolf.
Good morning, Judge. How are you?
I'm doing well. I hope you are as well. Is this your case?
Yes, Judge.
Okay,
And reviewing the police report, it appears that there was some CCTV surveillance at the MARTIR station, which picked up a scuffle between unknown person and I'm trying to get a clear understanding, because it indicates a male that they were one of the persons was a unknown person, the other person was a male. Indicates that there was a patron that was aggressive, made an aggressive motion towards someone with the last name of YOO, and the patron boarded the bus and continued riding. And then on that same day, the officer obtained a still black photo from the CCTV, and they created a bolo. And then later that day, Corporal Sparks informed Detective Bearden that they made an arrest of a subject matching that bolo. And that also that person was arrested for a similar incident in the past that involved physically assaulting another male patron. And that subject was identified as this defendant, Judge. With our limited access, that is the most that I could suss out about it, but clearly it was this defendant that was identified on this occasion and on a prior occasion. She does have 8 cycles. They do involve shoplifting, financial card fraud, theft, and two disorderly conducts. The state's offer in this case, and I know she wants to be heard on bond, but I want to let the judge know what the offer would be in the case. It's 12 months to serve, 54 days, credit for the 27 days, which I'm sure it's a couple more days that she served, balance probated, stay away from all MARTA, and no further contact with the victim, Mr. Woo-Sang Yu, and then a 12 week anger management. The state is asking for a good bond in reference to this defendant. There were 2 disorderly conducts. There was in 2018, there was a conviction. In 2023, there was an arrest for it. So I'm not sure of the outcome of that. And I'm not sure the facts on that, but there's some history with disorderly behavior. And there's also a battery arrest that was dismissed from 2019. So we are asking for a good bond. It appears that perhaps this defendant has issues with anger management. So we will ask for a good bond for $2,000, Judge. Of course, we also ask for stay away, no weapons, no contact with the victim in this case.
Okay, Ms. Wolf, Ms. Lewis informs me that I set the bond on this case back on at the SEA calendar on February 5th of $1,000 good bond at that time. So that's what her current bond is, it's my understanding. If nothing further, Ms. Wolf, Ms. Vigiletti?
Yes, Judge. So first I'll just say in this case, Ms. Wheeler did believe the complaining witness was coming at her at the bus station. We all know how many cases take place at MARTA. She acknowledged that she did strike him with the reasonable belief that she was coming at him. There is a reasonable self-defense argument to be made in this case. I do want her to have the opportunity to prepare a proper defense. Kayla's been living in Atlanta since high school. 10 years ago, she works at a temp agency called First Step Staffing. She was actually set to start a new job through the agency when she was arrested. She needs to be reassigned. She's also in her 2nd semester of Generations College Online, which is a private accredited online university based in Chicago, where she's studying entrepreneurship. She has now missed 3 weeks of class already. She was given the $1,000 surety bond at her first appearance. She was all set to pay that. She has some savings. She was ready to get out. Unfortunately, her roommate, who my understanding is a family friend, is a disabled elderly gentleman, and he physically is not able to come to the jail to pay. You know, she told him, here's where you find the money. I have the money. I'm prepared. He wasn't able to bring the money to her to pay the bond. Her mother and brother just moved away, and so Ms. Wheeler is in a position where she has the ability to make bonds. She just doesn't have access to her funds, which means she's missed almost 3 weeks of class. She doesn't want to withdraw for the semester. She has this reasonable defense that she would like to present, but I'll also add that although she does have some criminal history, she has 0 failure to appears. She takes court very seriously. She always shows up for court. She tells me, obviously I can't verify. I couldn't find any failure to appears either. And so kind of for all of these reasons, I'm asking if you'd consider converting this to a signature bond today.
Okay, given that I set the bond, that it would be a time served offer, it is a time served offer, it appears that she's been in custody for the past 2 weeks. I will modify it, Ms. Vigiletti, to a $5,000 signature bond through pretrial, 1-day anger awareness, no further contact with Woo-Sang Yu, stay away from MARTA, and no drugs, alcohol, or weapons while out on bond.
Thank
Okay,
you.
okay, did you get that?
5,000 signature bond, 1-day anger awareness class, no contact with the complaining witness, no alcohol, drugs, weapons.
Yes, and do you have her contact information for Ms. Tyson?
I do not. I have to get that.
Okay.
to her.
Okay, so if we can get her contact information for Ms. Tyson, I'd appreciate it. Is that what you need, Ms. Tyson?
Yep, and she did have 2 FTAs in the last year.
apologize.
It's okay. Yeah, so if you have the contact information, just send that to me
Okay.
too, along with the other one.
Judge, also.
Yes, Ms. Wolf.
When council repeated the conditions, I didn't hear the stay away, so I wanted to make sure that that is a condition and understood. It appears that the defendant, I'm not sure if that's her means of getting to school or whatnot, but we are okay, good. So we are asking for that stay away.
Yes, we
Okay,
did
and-
discuss that, and Ms. Wheeler does have a bicycle and has a friend with a car, so we're prepared for stay away from MARTA.
Okay. Did you have something for me, Ms. Lewis? Or did you? No? All right, good luck to you, Ms. Wheeler.
Your Honor,
Yes,
we were unable to locate Miss Alexis Howard and Sandra Kelly.
okay, so Sandra Kelly is position number 20. And the other one, I believe, is position number 18, so.
Correct.
I'll see what, all right, so, have we completed everybody that you have there at ACDC?
Yes, Ms. Johnson wanted to know if she's gonna be released today. She received time served.
So it typically takes 24 to 48 hours to process someone out of the jail.
Okay, thank you so much.
Sure. How about Alexandria Neves? I spoke with her yesterday. Is she available?
Alexandra,
What position is she?
Position 26.
okay, give me a few minutes. I'll locate her for you.
Okay, I think I have her location here because I visited her. Would that be helpful?
Yes.
Okay. It should have it. I'm sorry, I might have overpromised here.
You said Neves?
Yes.
Nieves.
Oh, I'm sorry, it's Nieves.
Okay,
I'm sorry, I should have it here and I don't, but I can keep looking.
Well, let's see if they can find her, and if they can't, then
Okay,
we'll let you know. Okay, so who do we have next?
Mr. Green, South Annex.
Okay,
May I please say the position numbers, because there's a lot of cases on the calendar.
I apologize. All we have is an email. We just have his booking number. We don't have the position.
okay. Is
14,
this Sterling?
Miss Lewis. 14, Miss
Is it-
Lewis.
Thank
Oh,
you.
well,
This-
actually, it's 2.
Is this Mr. Sterling Green?
No, it's position 13, that's what it is.
13, sorry.
Okay, Rosavier Green?
Mr. McKay.
That's the wrong green.
Rosavier Green.
Tell me your names, whoever's at the South Annex.
Not Green.
What's the first name?
Makai.
Guyver?
Makai. MEKHI.
We don't have anybody by that name on our calendar today.
Hi, Judge.
We don't have.
The greens that we have today are Rosavier Green and Sterling Green.
I apologize. On the email that we have, it says he's supposed to be at the 9:30, and we have his name for South Annex.
Okay, is there another court going on at 9:30?
Yeah.
It says Judge Cox.
Okay, yeah, no, this is the SAP calendar. Misdemeanor. Okay.
I appreciate you.
Okay, thank you. Okay, courtroom 2?
Yep.
What would you like?
I need to
Where
do.
would you like for me to go now?
Your Honor, they both need to do interviews for everybody that's in here.
We have a negotiated plea ready for Mr. O. Brown. We have a non-negotiated plea ready for Mr.
So we could go.
John DuBose.
Okay, you all tell me, would it be easier for you just to interview everybody and get that out of the way and then
Please,
we,
Your Honor, because all this going back. and
right,
forth,
going back, I agree with, yeah, so what I'm gonna do,
Get a few people interviewed. and then
But it
okay.
wouldn't hurt to do two off the bat right now, Your Honor. They're ready for non-negotiated.
But that is, if Officer Norris, I'm gonna do it whatever way you wanna do it, so.
Thank you, Your Honor.
if you want them-
2 minutes and then.
Yes.
Review, and then we'll get
Okay.
back on.
And you let me know when you're ready to go. Until you're ready, then we are going to be in recess, okay?
Thank you, sir.
All right. And so the court will be on recess until courtroom 2 comes back with us. I appreciate everybody's patience this morning.
Your Honor,
Yes.
okay, Miss Alexandra Nevis, she is on her way to downtown court.
Okay,
Position
somebody else,
26.
somebody else's court?
Yes, sir. I'm not sure which one, but the deputy is en route to take her to outer court. They're in intake
Okay.
right now.
Okay. So when they come back, I'll inform Ms. Vigiletti of that. Thank you.
Thank you.
Your Honor, do you want to go with positions 3 through 5?
I would, but I don't have any attorneys with me right now. They're all in courtroom 2 interviewing people.
Oh, okay, okay,
Okay, so as soon as they come back, I'll let them know that y'all are ready, okay?
okay.
All right, thank you.
Yep.
Hello?
Yes, ma'am.
Hi, Judge. Yes, I'm Alexandra grandmother, Alexandra Nieves' grandmother.
Oh, yes, good morning, ma'am. Did you hear what Officer Milton told me about your daughter?
Yes, but I thought she was supposed to be in your court. I don't know what's
Well,
going on.
Apparently, I believe that she was supposed to be in my court this morning, Ms. Davis, but apparently she's supposed to be in somebody else's court also.
Oh, wow.
So
So what should I do? I got you in on Zoom, so I don't have a Zoom
okay.
for that.
Well, I don't have the Zoom for you either, unfortunately, Ms. Davis. I take it that it's a Superior Court case. I'm not sure how you can get in touch with them to try to find out what courtroom she's in today. But I know she's not with me today, so we'll give you notification when she's back in my court, okay?
Okay, today?
No, she won't be with me today, more than likely.
Okay, then you don't have any other court date for her?
I do not at this point in time, ma'am. More than likely, she might be with us on Thursday if she's not here today. We have another,
yes.
okay?
Yeah. Okay.
All
okay,
right.
Thank you so much.
You're welcome. You have a good day, ma'am.
You too. Bye-bye.
Yes, Attorney Abasi.
Good morning, Your Honor.
Yes, good morning. I received your message. On position number 2, Richard, is it Tate?
Yes, it's Tate. I was retained solely for first appearance, and I've not had any contact with him since that time.
Okay,
I was retained originally by a friend of a friend, and he's several times, I guess, tried to reach out to Mr. Tate, and I've just not gotten any response.
okay, so I guess what you're telling me is at this point in time, you're not representing him as this matter moves forward.
Yes, Your Honor, that's correct.
Okay, so what I'll do is I will have I'll have the public defender see if we can talk with him this morning to get him some representation.
All right, thank you so much. Is he in custody?
I do, well, generally speaking, I'll say my calendars, everyone's in custody. But as you can see, if you've been on with us, we're having difficulty locating people. So I can't give you a definitive as to whether he is or he isn't.
Yeah, that is my understanding too. A few days after first appearance, I checked and I said, is he in custody? And they told me he was not an active inmate. So
okay,
hopefully we'll
so
find him.
we will try to round him up, and if he is in custody, then I will do as I said and see if we can have a public defender speak with him.
Thank you so much, Your Honor.
All right. Anything further this morning?
No, sir.
All right. Have a good day.
Thank you.
Judge, I'm prepared with 5 clients if you're ready to proceed.
Yes, Ms. Vigilante. We also have at jail courts on the iPhone, positions 3, 4, and 5, I believe.
Those are all Mr. McLean's clients, and he is still doing an interview right now.
Okay, I'm trying to, he's got just not guilty on there.
Yes, that's right. That's right. And you spoke with Mr. McLean yesterday, right, sir? Yes, that's right. This was a not guilty plea.
Okay, so I'm just saying if I can release them. Is he gonna file a waiver in the cases?
Let me ask really quickly. Judge.
Okay, thank you.
Sure. Your Honor, number 3, 4, and 5 is Mr. Coakley. And he is.
Yes. Okay, and I guess my question was, do you plan on filing a waiver of
I can
arraignment?
file a waiver. I'm sure I've got his permission to do that. Yes, he was adamant, so yes. I can.
Okay, well, very good. I just wanted to release them. They've been here for a while now. So, Mr. Coakley, your case will be returned to the division judge and you'll get notification of your next hearing date, sir. Okay?
Yes.
All right. Have a good day, sir. Thank you, Joe Court's iPhone. I appreciate it. Okay, Ms. Vigilante, where would you like to start?
Position 30, Nicholas Ragsdale.
Okay, and what's the announcement?
Mr. Ragsdale would like to accept the plea as offered by the state today, so we're just asking the court to accept the plea as recommended.
Okay, good morning, Mr. Ragsdale. I'm Judge Eric Morrow. This is the state all-purpose calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. Yes, Ms. Wolf.
Judge, the offer on this case was 12 months to serve 32 days, credit for the 16 plus days he's been in, balance prorated, and stay away from 595 Piedmont Avenue, which is Walgreens.
I'm sorry, the offer I got says balance suspended. Is that a typo?
I apologize, you're correct, balance suspended. Thank you.
Thanks.
Okay, anything further, Ms. Vigilante?
No, Judge, Mr. Ragsdale is prepared to accept the plea as offered.
Okay, Mr. Ragsdale, it's my understanding that in case 24 CR 0000643, you wish to plead guilty to criminal trespass, is that correct?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Ragsdale. Good luck to you, sir.
Okay.
Position 37, Jaden Thrift.
And what are we doing with Mr. Thrift today?
Mr. Thrift would also like to accept the plea as offered by the state, so we just ask the court to accept the offer as recommended today.
Okay. Good morning, Mr. Thrift. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, Mr. Thrift? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Yes, Mr. Rhodes.
Yes, Your Honor, as it relates to Mr. Thrift, I'm showing this as his first arrest for willful obstruction of law enforcement officers. The state's, and loitering and prowling. The state's offer is a time served offer of 42 days. He's already served 21 days since January 31st of this year.
Okay, so it's 12 months to serve, 42 days, credit for time served, 21 days, balance suspended.
You could do it like that or just,
Okay. That's how we that's how we normally do the paperwork,
Okay.
Mr. Rhodes, if that's fine with you.
yeah, absolutely.
Okay, is there a stay away?
I don't have a stay away, Your Honor.
Okay, just wanted to make sure. Thank you. Yes, Ms. Vigiletti.
Nothing to add, Your Honor. Mr. Thrift is prepared to take the plea as offered today.
Okay, Mr. Thrift, it's my understanding that in case 24 CR 000576, you wish to plead guilty to willful obstruction of a law enforcement officer and loitering and prowling. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Sir.
Is that a yes?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
Okay, I'll accept the plea as negotiated, Mr. Thrift. Good luck to you, sir.
Thank you, Judge. Position 21, Maestriani Marshall.
Yes, and what are we doing with Mr. Marshall this morning?
Mr. Marshall would also like to accept the plea as offered by the state. So we just asked the court to accept the plea as negotiated this morning.
Okay, Mr. Marshall is, I'm Judge Eric Morrow. This is the state court all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Okay, thank you, sir. Mr. Rhodes?
Yes, showing that Mr. Marshall is a multi-state offender, but he is also residentially challenged. He was caught sleeping in a parking garage where he had been previously issued a criminal trespass warning. Given that, the state is prepared to offer a time served offer of 52 days, credit for time served, which I'm showing is reflecting as 26 days, and it may be more than that now but I do see that he was booked in on January 26th of 2024. So I guess for purposes of this plea, it will be 12 months served, 52 days, balance suspended.
Okay. Anything further, Ms. Vigiletti?
No, Judge. Mr. Marshall is homeless, but has been working with someone from PAD to secure housing. So hopefully this will be the last criminal trespass we have here.
Okay. Mr. Marshall, it's my understanding that in case 23 CR 005746A, you wish to plead guilty to criminal trespass. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Good luck to you, Mr. Marshall.
Thank you. Thank you. Thank you.
Next, I have position 31, Tyvion Ray.
Okay. And what are we doing with Mr. Ray today?
Mr. Ray would also like to enter a negotiated plea today.
Good morning, Mr. Ray. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Can you raise your right hand for me, please? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. Mr. Rhodes?
Yes, Your Honor, I'm showing that this is Mr. Ray's first arrest. The state's recommendation as relates to Mr. Ray is 12 months to serve 58 days, credit for the time he served. I'm reflecting that he served 29 days already. I am asking that he stay away, asking that the judge order that he stay away from Peri Peri Grill. I'm also asking that the court direct him to take an anti-theft course, to complete 40 hours of community service. And once all the conditions are completed, that the probation will terminate upon completion of all conditions, Your Honor.
Ms. Vigiletti?
Yes, Judge, I've spoken with Mr. Ray. He already has ideas for where he wants to do his community service. He did have one minor concern that I'd like to address today. Mr. Ray does work at Lowe's that's in the same sort of strip mall as Peri Peri Grill. They're not right next to each other, but Mr. Ray just wanted some confirmation that it's okay to, you know, still go work at Lowe's, even though it's kind of in that same parking lot area as Peri Peri Grill.
Of course, I'm not going to keep him from making a living. So of course you can go back to work at Lowe's, Mr. Ray. Just don't go to Peri Peri, okay?
Yes, sir.
All right, so it's nothing further, Ms. Vigiletti.
No, sir.
Mr. Ray, it's my understanding that in case 23 CR 006724C, you wish to plead guilty to theft by taking, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Ray. When you complete the terms, you won't be on probation any longer. So the sooner you get it done, the sooner you be done, okay?
Yes, sir.
All right, good luck to you, sir.
Is there a particular address for that location or just the name?
Give me one moment, I can get you that address.
Who do we have in the jail court's iPhone, just so I can let the attorneys know?
We have position number 1, SQ Rice.
Okay, it's my understanding that that's going to be Mr. McLean's case, so when he comes back up, we'll get it addressed. I'm not sure if Mr. McLean needs to speak with him or not.
Yes, Your Honor, that should be a Zoom breakout if he's not available to come into this courtroom, and we can do that on my iPhone.
Okay, let's see. Are you still working? We still have positions for you, Ms. Vigiletti, that you've interviewed?
Judge, my last position that I've interviewed is the woman at ACDC, and I don't see ACDC on the screen anymore. The Alexandria Nieves that we spoke about earlier this morning.
Okay, they were going to try to see if they could locate her, and I guess they still attempting to do so. So,
excuse me, Judge. That was the young lady that they said they transferred to another.
Oh, you're right. You're right, Ms. Lewis. Thank you. I'm sorry, Ms. Vigiletti. Yes, Officer Milton did say that for some reason she was brought downtown, maybe in somebody else's courtroom this morning.
Oh.
So I think that we're going to have to reschedule her until Thursday, I guess.
Okay, thank you.
Well, can we
Okay.
make it Tuesday?
No, because I don't know if I'm not going to punish her because this is not her fault. So I know that we have large calendars, but I don't want to punish somebody when it's not their fault. Mr. McLean, I would rather do your cases that you have before I release you, so I can get rid of some of the people that might be in courtroom too. So jail court's iPhone, if you'll stand by with me, I'll get Mr. McLean to you as soon as I.
Okay.
Good morning, Ms. McLeod.
Good morning, Your Honor. I have position 27, Eric Parker.
Have you already spoken with him?
I have not, Your Honor. I just want to be able to speak with them. And I also sent the state a message, Ms. Wolf, in chat concerning that case.
Okay. Do we still have Norris in the courtroom there?
No, sir. I say so.
Okay. Oh, yes. Good morning. Let's see. We will need, is Mr. Eric Parker in your courtroom?
No, we weren't able to find him.
Okay. So they still can't locate him for some reason, Ms. McLeod. We'll see if let's see, the offer. I can't push this one out a bit. The offer is not a time served offer of 60.
It isn't, Your Honor, right?
Okay, so let's push this out. Is a week enough time, Ms. Lewis? I can't hear you.
I'm sorry, what position are we talking about right now?
Your position number 27. I will push this one out a week if I can. If is that a good time?
That'll be fine. We can push it out to next Tuesday, the 27th.
27. Okay, so hopefully, Ms. McLeod, that'll give you enough time for them to track him down and for you to interview him. Okay.
Thank you, Your Honor.
All right. Do you have anything further on my calendar this morning?
I do not, Your Honor.
Okay. Will I see you this afternoon?
Yes, Your Honor.
Okay. I'll see you in a little while then. Have a good rest of your morning.
Thank you, Your Honor.
Okay. Okay, Mr. McLean, are you ready?
Yes, Your Honor.
Okay. Who do you want to start with?
Anything, I've got them all lined up, so any order the court wishes.
Well, you tell me, because I don't know who they are.
Let's see, breakout Zoom for number 1. I've got a non-negotiated plea on number 2. His name is Ozine Brown.
Yes, good morning, Mr. Brown. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good.
Thank you. Can you raise your right hand for me?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you. Given that this is non-negotiated, let me start with pre-trial first. Ms. Tyson, do you have the history for Mr. Brown?
I'm sorry, you said this is two on the regular calendar?
Yes.
Okay. Mr. Brown, looks like he has 38 arrest cycles beginning in 1977. One moment. It says 38 arrests out of Georgia and 9 cycles out of Florida. So it looks like within the last 10 years. Let's see. He has a failure to appear from 2019. At least 3 violations of probation, felony conviction out of Fulton County for burglary in the 1st degree. The disposition date is February of 2022. He received 8 years probation on that case. It looks like he may have a open possession and use of drug-related objects. That arrest date is September 21st of 2023. No dispositions listed on the GCIC. And his last arrest was February 6th, 2024 for the case that's on the calendar and also a violation of probation. Do you want his Florida history also, Your Honor?
No, that's fine. Thank you. I appreciate it, Ms. Tyson.
Okay, you're welcome.
Yes, Ms. Wolf.
Judge, I do have that, I would note that most of his items on his GCIC are theft related, burglaries, theft by taking, and he was convicted, it looks like July 13th of last year for a theft by taking and had to pay restitution to someone on that particular case. So we asked, make the court aware of that. The state's offer on this case is 12 months to serve, 90 days in jail, credit for the time he's served, 40 hours community service, anti-theft course, stay away from 456 Parkway Drive, Atlanta, no further contact with Mary Anderson, and restitution amount is $1,000. What occurred in this particular case is that the victim in this case garage is broken, and when she looked at, she had some items missing, and when she viewed her video camera, it captured a black male wearing black and gray and some white sneakers in her garage and take items, took a thermometer, a ZARA package, water filter, dishwasher set, dishware set, and she advised that since her door is open, it was, broken, it was open. When the officer arrived to the location the next day, he was not that location, but he was canvassing Ponce de Leon, and he observed the individual matching that exact description, and he did detain the defendant. And then he looked at the video evidence again to verify that it was indeed the same person. He did verify. The officers then arrested him and saw that he had a Fulton County Marshal Office warrant for larceny. So I'm not sure of the status of that larceny case, Judge. So we're just asking the court to consider his criminal history and his recent criminal history and follow the state's recommendation.
Ms. Wolf, do you know if the restitution, was that just an estimate, or were you provided with documentation to validate that claim?
We do have receipts. I have, I'm not sure if the judge wants me to mention how much, the way it printed out, it kind of cut off some of the pricing on it, but I can certainly send it to.
No, I just want to know if it was confirmed if your office confirmed that it's $1,000 in restitution.
Yes, Judge.
And that Ms. Anderson did not get her belongings; they were not returned to her.
Her items were not returned, but I would ask the court if we can, if he is placed on probation, that we can set a more exact detail amount on the restitution, because I'm looking through the receipts, and from what I'm seeing, I'm not sure if it equals up exactly to 1,000. So I would rather his actual number be, stated be correct. And since some of the receipts are cut off, I want to be able to provide that to probation or at a later date, Judge.
Well, I cannot, I can't ask this man to plead to something that he doesn't really know what he's pleading to. So if you tell me that you have $1,000 in restitution that you can verify, I'll have him do that. But if it's going to go up to 2,000 or 3,000 possibly, then I'm not doing that.
Judge, no, in speaking with the victim, she gave the amount of $1,000. And looking at the receipts, if the court will give me a second, I'll calculate the receipts that are in front of me, Judge, to give her.
Okay. All right. Thank you. I appreciate that. And while you do that, I'll go on to Mr. McLean. Yes, Mr. McLean?
Your Honor, Mr. Brown and I have had a discussion of a certain sensitive item here, which has to do with dignity and confidentiality of information. And even after that discussion, he does wish me to tell the court that he was in Grady High School in special education. He says, would you tell the judge that sometimes I'm a little bit slow in picking up information? I said, well, that is, I'll put it that way. Your Honor, he does have, he acknowledges what his past has been. He did agree with the state about it was an open garage. That provided a temptation, Your Honor. He is sorry that he fell to that temptation. He and I had a discussion. I said, special ed or not, we can learn a little bit of law here. So we talked about property and about whose property, where your feet are, what ground is owned by people, and what things are owned by people. We had a good discussion of that. He is determined to not have any of this in the future. The reason it's a non-negotiated plea is, Your Honor, this was approximately 15 days ago. Is that correct? And the offer was the 12 months to serve 90 days with credit for 15, and that would constitute a 30 extra day jail sentence before his probation starts with 40 hours community service and the anti-theft course. His nephew is going to be receiving his Social Security check. It's not a disability check, it's based on his age. And when his nephew gets that check on March 3rd, Mr. Brown is deathly afraid that that check is going to get spent right away. And if Your Honor could either give him time served as the jail portion of the sentence to start his probation tonight, or something less than March 3rd, that's what he would really appreciate. He is going to pay the restitution as the state is adding it up. I'm sure it'll be somewhere between, sounds like it's going to end up being between 600 and 700, but I'm guessing myself, it could be 400 or 500. But when he's going to pay it back, he's got a check coming in, but it's not a disability check. It is a Social Security pension type check based on his age.
Okay, well, he'll have a claim against his nephew or whomever it is if they steal from him. This has nothing to do with somebody stealing from him. This has to do with him stealing from other people. Sure. He had a theft by taking conviction back in 2023 in this court itself and got 28 days. So I'm certainly not going to give him less than 28 days. He was convicted of burglary in 2023, convicted of theft by taking in 2019, convicted of burglary in 2019. So no, I will accept the state's recommendation as far as the jail time goes. As far as the 40 hours of community service and theft and anti-theft class, I don't suspect that I would issue that, but I am going to have him pay back however much he took from this lady, and I am going to have him on probation for the entire term. So that will be the court's sentence. If
we may go mute for a minute, I will make sure that he understands the elements the court mentioned. That if we go on mute for just a moment.
Okay, if you'll put a. Did you get that number, Ms. Wolf?
Judge, it appears to be $809.12.
Okay, thank you.
And that's to be paid to Miss Mary Anderson.
Ms. Wolf, can you please DM me in the chat of the victim contact information so I can provide it for probation? I'll need her address and if she has a phone number or email so we can forward to probation for the restitution, please.
Yes, Mr. McLean.
Your Honor, he understands and agrees to the 809 figure. He understands and agrees to the 90-day figure. He understands 15 days credit means he will serve an extra 30 days in jail starting now. He appreciates, he appreciates the court knocking out the idea of the course because he might have difficulty with it. He appreciates the court knocking out the 40 hours. and he feels the court has fashioned a fair sentence for him, and he accepts it.
Okay, if nothing further from counsel, Mr. Brown, it's my understanding that in case 24 CR 000651, you wish to plead guilty to theft by taking, is that correct?
Speak up louder. Speak up louder in the microphone.
Yes, sir.
Okay, you've been represented by counsel. Are you satisfied with his representation?
Yes.
Are you under the influence of any drugs or alcohol this morning?
No.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No.
Okay. Court sentence will, Mr. Brown, will be 12 months to serve 90 days, credit for time served 15 days, balance probated, stay away from 456 Parkway Drive in Atlanta, no further contact with Mary Anderson, and restitution in the amount of $809.12. Because of your history, I'm going to require that you be on probation for the entire 12 months. Good luck to you, Mr. Brown.
Mr. Scott, down there.
Good enough. Thank you. Good to meet you.
So I ain't got any other charges.
Not that you're aware of.
Okay, who do we have next, Mr. McLean?
Let's see, that was number 2. Let's look at number 3, 4, 5. We're not guilty. 6. Let's see who 6 is. Patrick Davis.
Okay.
What was the announcement on Patrick Davis? I know we had a Henry Davis. I don't think we had an announcement yet on Patrick Davis. Number 7 is Mr. Dubose, and he is ready.
Okay, so if he's not in the courtroom with you, I guess they haven't been able to locate position 6, Mr. Davis, so.
We haven't found Patrick yet. Mr. Dubose, if you come have a seat here.
What are we doing with Mr. Dubose this morning?
Let me confirm this. I believe it's a non-negotiated plea. Is that correct? Okay, that's a non-negotiated plea.
Okay, good morning, Mr. DeBose. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your, good morning, sir. Do you agree to have your case heard by video?
Yes, sir.
Can you raise your right hand for me?
Yes, sir.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
All right, so what I have as far as his history goes, 27 cycles and 2002 conviction for disorderly and simple battery, 2010 arrest for battery family violence, 2018 an arrest, 2021 conviction of disorderly conduct, 2023 an arrest for battery. Do you want to supplement that, Mr. Rhodes?
No, that's what I have as well, Your Honor.
Okay.
Yes.
That is what the state conveyed to us through their writings, Your Honor.
Okay.
Yes, Your Honor.
Can you give me the facts, Mr. Rhodes?
Yes, Your Honor. A brief summation of the facts is that it appears that on February 2nd of 2024, Mr. DeBose entered into the Little Big Bear. I believe it's a grocery food mart.
Yeah.
1660 Jonesboro Road, where he had an altercation with Mr. Arthur Clems. During the altercation, Mr. DeBose can be seen on surveillance having struck Mr. Arthur Clems in the mouth with a metal pole. And again, this was observed on video footage by law enforcement officers, Your Honor. Mr. DeBose then left the scene. Mr. Clems was there and he gave his account of what happened. Store clerks were able to turn over that surveillance to law enforcement officers. Mr. DeBose later came back to the scene and store clerks called law enforcement, and when they went to arrest him, he in fact did resist arrest. It took multiple officers to get him under arrest. And once he was under arrest and in the backseat of the officer's vehicle, the officer reported that he spat on him several times from the back of the vehicle and handcuffed. As such, Your Honor, the state is recommending a sentence of 12 months to serve 90 days. Credit for time served, which I'm showing is 19 days, and then the balance be on probation. We're asking that he stay away from the Little Bear Food Mart, which is 1660 Jonesboro Road, and that he has no further contact with the victim in this case, Mr. Arthur Clem. We're also asking that he completes 12-week anger management as well, Your Honor. And based on the defendant's history, we feel that this is a generous offer. Thank you.
Thank you, Mr. Rhodes. Yes, Mr. McLean.
Your Honor, if I may mute for just a second, I need to double check. I'm getting some questions from my client. I want to make sure
Okay.
that ends with what we're doing. Okay. Your Honor, we're back. Thank you.
Okay.
Your Honor, had this case gone to trial, Mr. DuBose would have proposed to do a self-defense plea because he says the guy grabbed him for no reason. However, considering the vicissitudes of litigation, he wishes to offer the non-negotiated plea and ask the court to consider giving him time served or something pretty darn close to time served on the jail portion of his sentence. He realizes he did strike the person, and that's unfortunate. He realizes the case is where it is. He says if the video were viewed, it would note that the person came up to him, doesn't know this person, came up to him, grabbed on the side, and that's why he reacted. But Your Honor, instead of putting this in front of a jury, he'd like the court to consider giving him time served. And he realized the court does not have to follow anyone's recommendation, and he does plead guilty. We went through all the questions about knowing what you're doing and not being on medication and alcohol and such as that, giving up your trial rights. So I believe that he is entering a knowing and voluntary plea.
Given the facts and the history, Mr. McLean, I'll be accepting the state's recommendation if your client chooses to plead guilty.
Okay, let me make sure he understands. Yeah. Your Honor, he says he's ready to go forward with the plea, and he would like to ask the state to read the terms one more time, just to make sure he hears it. And we've gone over each element and the meaning of it.
Yes. Mayor, Your Honor, relates to the state's recommendation. It is 12 months to serve 90 days. He will receive credit for time served, which we reflect as 19 days as of today's date. The balance will be on probation. We're asking the court to order a stay away from Little Bear Food, which is 1660 Jonesboro Road, and that he has no further contact with the victim in this case, Arthur Clems, that's spelled C-L-E-M-S, and that he completes 12 weeks of anger management.
So I calculate, Your Honor, an approximate release date onto probation from the jail portion of the sentence at approximately the 17th day of March.
Okay. Anything further, Mr. McLean?
Is there anything further, Mr. DeBose? That's it, Your Honor. Thank you.
Okay, Mr. DeBose, it's my understanding that in case 24 CR 0000600, you wish to plead guilty to battery and simple battery against a police officer. Is that correct?
Is that?
Say it again.
Is that?
Are you under the influence of any drugs or alcohol this morning?
Is that?
You've been represented by counsel. Are you satisfied with his representation?
Is that?
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Is that?
Has anyone forced or coerced you to plead guilty? I'll accept the plea, Mr. DeBose. The sentence will be that as articulated by Mr. Rhodes. I will have your probation go to a non-reporting status once you complete the term. So the sooner you get it done, the sooner you won't be on reporting probation, and the sooner you won't have to pay those fees, okay?
Is that? Thank you.
All right, good luck to you, sir.
Thank you.
You're welcome.
Mentioned. Let's see, that was number 7, wasn't it?
That's correct. Who do we have next?
Let's see, number 8 is a not guilty from Mr. Henry Davis and a bond request. Henry Davis, please step up to Your Honor, as he's coming to the chair, I understand that that might not be correct. What do you want to do then? He's going to accept the negotiated plea, Your Honor.
Okay, so what I have down, well, I'll just let Mr. Rhodes give it, but it's a time served plea, it appears to be. Let's see, Mr. Davis, good morning. I'm Judge Eric Morrow. This is the all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? I'm sorry, is that a yes?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you, sir. You can place your hand down. Yes, Ms. Wolf.
Judge, my understanding is that since it does appear that there is a 8-week anger management course, that it will be some probation, balanced probation. The offer is 12 months probation, serve 56 days, credit for time served of 28 days, 8 weeks anger management, 40 hours community service, and no further contact with Simone Lee.
Is that your understanding, Mr. McLean?
It is, Your Honor, 12/56/28. Right. Now, is it your understanding that you'll be getting time served as the jail portion of your sentence? Your probation will start now.
Yes, sir.
For the remainder of the 12 months, you will complete 40 hours of volunteer service to a nonprofit and 8-hour course in anger management. I believe he understands the offer, Your Honor.
Okay.
I'm sorry if I may, one more thing. My understanding is that they are the parents of the same child. So I know I have a no further contact with Simone Lee. I guess I would add a third party transfer or whatever for their child, so that it doesn't totally block him from that ability of seeing the child.
Okay, yes, I don't want to keep Mr. Davis from seeing his child, but Mr. Davis, you cannot have any contact with Ms. Lee, so you'll have to go through a third party for visitation with your minor child. You understand that?
Yes, sir.
Okay. Anything further before we take the plea, Mr. McLean?
No, Your Honor.
Okay, Mr. Davis, it's my understanding that in case 21 CR 0000142J, you wish to plead guilty to criminal trespass and obstruction of a law enforcement officer. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Mr. Davis, let's see. When you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get the terms done, the sooner you won't have to actively report to probation and pay those fees, okay?
Yes, sir.
All right, good luck to you, Mr. Davis.
All right.
Thank you. That was number 8. I don't believe we have talked to Mr. Elliott yet, number 9. So, Hightower, Furtado, and Gask are ready. Now, Furtado is 10. Gask is 11. Those are ready. Furtado and Gask and Hightower are ready.
Okay, we'll call him on up, Mr. McLean.
Furtado, Furtado or Gask, come forward. Now, this is Mr. Furtado.
Yes, and what are we doing with Mr. Furtado today?
Negotiated plea.
Okay. Yes, sir. Good morning. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Sir.
Okay, you can place your hand down. Thank you. Ms. Wolf?
Yes, Judge. This particular case, involved, theft by shoplifting from T-Mobile. The offer on the case that I have noted is, 12 months to serve, 76 days, credit for time served of 38 days. Stay away from T-Mobile and anti-theft class. They also have noted restitution open for 30 days, Judge.
Okay. You don't have an amount for restitution?
Unfortunately, not at this moment. I do not, Judge.
Okay, then I'll have them pursue it through a civil suit if they choose to do so. Yes, Mr. McLean.
It's a negotiated plea. We asked the court to accept his negotiated plea, stipulate to the venue and the factual basis and the identification.
Mr. Furtado, it's my understanding that in case 22 CR 0000691J, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
Yes, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
I'll accept the plea as negotiated. Let's see, when you complete the anti-theft class, the probation will go to a non-reporting status. So the sooner you get it done, the sooner you won't be on reporting probation, okay?
Sir, thank you.
All right, good luck to you, sir.
Thank you.
Excuse me,
Thank you.
Ms. Wolf. Excuse me, Ms. Wolf. Is there a particular address for T-Mobile or all T-Mobiles?
All T-Mobile.
Mr. Furtado.
Great. Thank you.
All of the T-Mobile. They are cool for all.
Yeah.
And I do have a right to T-Mobile.
Who do we have next?
Mr. Grant, number 12, because I think number 11 is not present right now.
Okay,
Number 12 is Mr. Dennis Grant, and that's going to be a negotiated plea.
okay. Good morning, Mr. Grant. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, sir. Yes, Ms. Wolf.
Yes, Judge. The recommendation on this case is 12 months to serve 42 days, credit for time served of 21 days. Stay away from Woodvale Court, that's WOODVALE Court. And for him to have no further contact with Donnell Hawkins, Reginald Stewart, and Holly Northey, that's NORTHEY. Additionally, required to take an anti-theft course and complete 40 hours of community service. That is on the first loiter and prowling. On the second one, it will be 12 months to serve concurrent with the first one, and the same for the remaining charges, Judge.
Okay, thank you. Mr. McLean?
Your Honor. You understand it? Yes, Your Honor, that's a negotiated plea, so he asks the court to accept this negotiated plea while he stipulates to what the state has said and stipulates for the purposes of, excuse me, for the purposes of the plea, stipulates, of course, to venue, identification, and factual basis.
Okay. Mr. Grant, it's my understanding that in case 24 CR 000570, you wish to plead guilty to 3 counts of loitering and prowling and 1 count of willful obstruction of law enforcement officers. Is that correct?
That's correct, yes.
Are you under the influence of any drugs or alcohol this morning?
No,
You've been represented by counsel. Are you satisfied with his representation?
yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, I understand.
Has anyone forced or coerced you to plead guilty?
No.
I will accept the plea as negotiated. Let's see, Mr. Grant, when you complete the anti-theft course and the 40 hours of community service, I'll have the probation go to a non-reporting status. So the sooner you get it done, the sooner you won't have to pay the fees to report to probation, okay?
Sounds good, thank you.
All right, you're welcome. Good luck to you. So,
No, I don't think so.
Next, we have position 14, third degree.
okay.
Go right there. Coming up.
And what are we doing with Mr. Green this morning?
I believe that also, Your Honor, is a negotiated plea.
Okay, good morning, Mr. Green. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video? Was that a yes?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Thank you. Ms. Wolf?
Judge, this recommendation is global for both counts. Judge, is 12 months probation, serve 26 days, credit for time served of 13 days, balance suspended, and stay away from all MARTA.
Okay, so just so I have this straight, in the one that's on position 14 is obstruction of an officer and criminal trespass, and then there's also another criminal trespass that he is pleading to also. Is that correct?
Yes, Your Honor, we discussed the fact that there was also that 24 CR 00, actually 000422J.
Okay, I just wanted to make sure that we've got the paperwork right, and that's what the intent is.
Yes, Judge, I would just remind counsel and his client that a suspended that probation being suspended doesn't necessarily mean that he's off the hook, and we do need him to still stay away from Marta.
He understands he is under obligation to follow the conditions even during the period of suspension, which is the remainder of the 12 months. And that if he does not, and be proven in a hearing, then the case could be brought back up for further punishment, even though it is suspended.
Okay, and Ms. Lewis, is there something that you're confused about?
That I am, because the other case is not listed on the counter, and I just want to confirm what charge is holding him in jail. So are you saying that the 24 CR 000655 is the one he's currently in jail on, along with the 24 CR 000422J, or that's just the other charges is not located on his booking script? I just didn't want no confusion with the jail, because I don't have the other case on the counter, and I have to locate that file, because I don't even know what the status of that file is. So which one is he in jail on? The one that's on the counter? The other one is he just taking a plea for, right?
I would imagine that that's the case, but if we get the paperwork over to the jail on both those counts, then if something else is holding him, I guess they will keep him in. But I just want to make sure that they have whatever they need if nothing's holding him except for these charges that he's released. Ms. Tyson, did you have something?
He has 2 holds for Clayton County and Cobb County, and he does have an open felony case with no bond also.
Oh, okay. All right. So
okay.
Regardless, he won't be being released. Okay.
And Ms. Lewis, I can send you, there's another 24 CR case. I'll send it to you in the chat just so you can have it, just in case you need it.
Well, the other one is that they mentioned on the counter is the criminal trespass. That's the case in front of Judge Besson that's going to be on her counter for tomorrow for P&A. So I'll just have to contact the case manager for that particular case to let him know that he's taking a plea on this case. And that
okay, it's a battery family violence.
There's another one. Oh, well,
yeah.
I'm not aware of that.
I'll send it to you so you can look at it.
Now, Your Honor, my client is raising an issue about let's make sure this 24 CR 000655. By the way, does that lack a letter after it, or is it just? It does not have a letter after the last 5?
Yeah, Mr. McLean, due to the system and the situation with the what we're going through, the cases are not pre-assigned.
Right.
At the time, they're not going to have a judge assignment.
Right.
We have previous cases like this one. I'm pretty sure this case would have been assigned to that Division J, but
Right.
we're not able to assign.
I just want to make sure I'm doing the paperwork right. So I'll leave
Yeah,
the thing off of that.
leave the number off, leave the letter off. That's correct.
Okay. Now, Your Honor, I believe that he is the Sterling Green that is the subject of the 655 case. Now, on the 422 case, the Peachtree Center Station case, was there any question that was your case as well as Sterling Green? That's the Peachtree Center Station case. It's also a murder case.
I'm saying I don't have any Cobb County or any other arrests.
That's
what I'm saying. You could be confusing me with another green.
Okay, he says he does not have a Cobb or other hold, and that he doesn't have domestic violence. He doesn't have a felony, he doesn't have domestic violence.
I apologize. That's the other green that's on the calendar that has that. Yep. I apologize. That's the other green.
No problem.
Yep. Getting confused. Green's confused.
Okay, so now I'm confused. So he is, if he takes a plea to these charges, there's nothing holding him and he will be released, or is there something that's holding him?
We're not aware of anything holding.
Okay, I just want to make sure that that if he's supposed to get released because of these charges, that he is released. So, okay, Anything further before I take the pleas?
Your Honor, since that's bail is suspended, I will not get emergency contact information down from him. He's ready.
Okay. Mr. Green, it's my understanding that in case 24 CR 0000655, you wish to plead guilty to willful obstruction of a law enforcement officer and criminal trespass. And in case 24 CR 0000422J, you wish to plead guilty to criminal trespass. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No.
You've been represented by counsel. Are you satisfied with his representation?
Yes.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the pleas as negotiated, Mr. Green. Good luck to you, sir.
Good to meet you.
Hi, Tom.
Excuse me, Your Honor, this is jail court iPhone. The battery is dying on the phone.
Okay, well, can we, Mr. McLean, can we get you to speak with jail courts now?
Yes, Your Honor. Let me, all I need to do is zoom in and I'll go to that application right now and zoom in. Okay. Let's see.
Or are the rest of these people, are the rest of the young men that are in the courtroom, are they your cases?
One is.
Mr. Hightower is.
Okay, and the rest of them, who do they belong to?
This is. Mr. Sentmore is my judge.
Okay, so we'll do that while Mr. McLean is in the breakout room. Okay, so if once Mr. McLean logs on, if we can go ahead and put him in jail court's iPhone into a breakout room for me, please. Thank you.
Your Honor, it says connecting ...
Okay, thank you. Okay, thank you, Ms. Vigilante. Tell me who we have and the number.
Yes, this is position 33, Xavier Sentmore.
And what are we doing with him this morning?
Mr. Sentmore would like to accept the plea as negotiated.
Okay, good morning, Mr. Sentmore. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Sir.
Thank you. Can you raise your right hand for me? Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can put your hand down. Yes, Mr. Rhodes.
Yes, Your Honor. As it relates to Mr. Xavier Sentmore, looks like there are 15 cycles on his GCIC. His last arrest prior to this one was January 24th for the same charge of criminal trespass. We did dismiss that one because he was accepted into PAD. But again, he was rearrested 5 days later on this charge. The state's recommendation as it relates to this charge is 12 months to serve 46 days. My record reflects that he's already served 23 days. And then the balance to be on probation, that he stay away from La Vista Wall Apartments at 1155 La Vista Road Northeast. Judge, as it relates to the balance being on probation, I'm going to change that to balance being on suspended. I'm going to suspend the balance.
Okay, my calendar reflects that the balance is suspended. So, okay, thank you, Mr. Rhodes.
For some reason I have 12 MP, so that I thought that was 12 months probation. So maybe that's a confusion on my part. All right, thank you, Judge.
You're welcome. Yes, Ms. Vigilante.
I will just say real quick, Mr. Rhodes, it is confusing, but when they write BS after the days, they mean balance suspended. It took me weeks to figure that out. So that's
Oh, okay. Thanks for clearing that up for me, counsel.
Yes, Judge, I've talked with Xavier. He does have a social worker through PAD that he's working with, but they had not yet set up his housing when this took place. And so he's got her number. He's planning on giving her a call as soon as he gets out. the only reason he was in this apartment building is because he is homeless, and so that's what we're working on. And I did give him my contact information just in case anything falls through with Pad. We're gonna help him too. We don't want any more criminal trespass for homelessness here. So he's prepared. I think he's ready to get out of here and get working on some housing.
Okay, very good. Thank you. Yes, Mr. Seymour, it's my understanding that in case 24 CR 000552, you wish to plead guilty to criminal trespass. Is that correct?
Sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
No, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Good luck to you, sir.
Thank you.
Yeah, so it takes 24 to 48 hours to do the process out, but nothing's holding me here. So as soon as they get you out, you're out, okay? I will also just mention, because I know we're all working manually here, Mr. Sentmore's name is misspelled on the calendar. His last name is Sentmore. And Ms. Lewis, I have a couple of spelling corrections and I'll send them to you after court today.
No problem. Thank you.
Okay, thank you. And so the other gentlemen that are there are Mr. McLean's?
Yes. Yes, Judge.
Okay, so I guess we'll be in recess until Mr. McLean rejoins us. And well, before we go into recess, let me see. We have still a number of people that were able to locate. Are we still attempting to locate people, or are these the last two that we will have today? And that's, I guess that's
As of in program 2, yes.
okay. So is aside from the roaming iPhone, do we know if there are any others that are trying to assist us, or is that it?
No.
My understanding is that Officer Norris is trying to track down Tony Newman, because I did speak to him yesterday. I believe he's at the Marietta Annex. I know he was trying to make a call over there. I don't know that it will be possible. But Mr. Newman is prepared to take a plea, so I am hopeful that we can make that happen today. That's position
Okay.
4.
Okay, well, I appreciate that, but we still have probably 10 or 15 other people that are on this calendar.
Position number 23, Tony Myers is at downtown court right now.
Okay, so we won't be seeing Tony Myers today.
No.
Okay, what about position 22? I'll just go, since you're here, Ms. Vigilante, I'll go through your cases. 22, Dandre Minton. Or Minoton.
And he can't find him.
Okay, so we're still looking for position 24, Tony Newman. Is that right?
I believe so.
Okay, position 28 and 29, William Pascal.
Sir, I'm very concerned about Mr. Pascal, because I've been told for over a month that he's outsourced to Grady. But when I spoke to Sergeant McIntosh yesterday, she said it's very, very unusual for someone to actually be at Grady for a month. And so I am going to call Grady today to see if they will release any information to me, but I'm very concerned that he's back and lost.
Okay. Position 32 was a DA transfer. Did we get the transfer order on that?
From my understanding, Ms. Wolf just informed me, Judge, that they did not get approval of that yet, so she has to have it reset to next Tuesday calendar.
Okay. So position 32 will be reset until 2/27. Position 34, Calvin Sims.
Last I heard, Officer Norris told me positions 34, 35, and 36 are all lost.
Okay.
Is there any way that y'all guys can go to the logbook and check and see if they came out? Is, while you're physically there to go through their look? law book to see who's been booked out or who may gone?
Yeah, so my understanding, when I go to visit folks, that doesn't always happen, but my understanding, Officer St. Cyrin, Blunt, Norris, and Gothi are searching every page of every logbook every morning and are still not able to find people. And you can tell me if that's wrong.
Yeah, that's true.
I'm sorry, the announcements as it relates to 34 to 36, you said they were all,
Not able to be found.
oh, okay, lost.
Okay, and I guess I'll go over Mr. McLean's with him when he comes back. So as far as you're concerned, as far as you're concerned, Ms. Vigiletti, the only one that we are still possibly may get today is Tony Newman, position 24.
Yes, Judge.
Okay. And so on Ms. Vigiletti's cases, Ms. Lewis, you have the calendar there. If they have a time served plea, I would like for them to be placed on Thursday's calendar. If they don't have a time served plea, and it's gonna, we can place them on a calendar that's more in the future. But if they have a possibility of getting out, I don't want to hold them longer. So I guess as we go through the calendar at the end, we can determine where we need to place them.
What about the add-on position number 1? I think that's your case too, Mrs.
We took a plea on that, right?
No.
Yep, that's Zarkia Johnson. She was the very first.
Oh, that's right. Add-on number 2 will be the other one. I think that's Mr. McLean.
Yes, add-on number 2 has a private attorney who I believe joined us.
No.
Yeah, she joined us, Ms. Vigiletti, and she said that she was only returned to do first appearance. I mean, she was only retained to do the SCA calendar.
Okay.
So I need to see if we can have someone speak with him also.
Okay, should we assume he qualifies for public defender services, or should I take him through the application process?
I take it that you're gonna have to take him through the application process.
Okay.
And
was he brought?
Well, don't. And well, if they're on the SAP calendar, don't you all normally represent them if they don't conflict?
I do, but at first appearances, they typically run through a quick application just to make sure they qualify. I think it's a safe assumption they qualify if they're here. But I've not run into this before where they've had a private attorney for first appearance and now, so I'll just double check, but I'll do whatever.
Okay. All right, so he does have a time served plea, so we'll have to place him on Thursday's calendar.
Okay, I'll plan to represent him and make sure that I'm doing what needs to happen for that to take
Thank
place.
you, I appreciate it. Okay, and I did have one, we did have one probation case. Ashley Harvey did
Yes, I spoke with Mr. Allison. I don't believe she's here today. Oh, no, she is. She told me that Judge Porter would like to see Ashley Harvey back in Judge Porter's courtroom, so there's no recommendation.
Okay, so she'll be placed on Judge Porter's calendar at some point.
That's my understanding of him.
Okay, all right, so we've dealt with that.
Any luck finding the Marietta and
Then girl says, he works for the kitchen.
this is what we're doing right now. We're just talking about how to find these people. Yes. That was Officer Norris. He's making one last attempt to find Mr. Newman today.
Thank you.
You say something?
I'll say it's strong.
2401595.
Court will be in recess until Mr. McLean rejoins us, or we find someone else. Ms. Vigilante, is there someone that we can take?
Hi, Judge. This is Tony Newman. And he has brought me some documents that I just need to take a look at really quickly here.
Okay, just let me know when you're ready.
Okay, thank you. We're ready. Judge, I do think Mr. Newman is ready.
There you go.
Okay, so what are we doing with Mr. Newman this morning?
Mr. Newman would like to accept the plea as negotiated today.
Okay, good morning, Mr. Newman. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You can place your hand down, Mr. Newman. Yes, Ms. Wolf.
This offer is time served, which is 54 days credit for time served of 27 days.
Okay. Ms. Vigilante?
Yes, Judge, the documents that Mr. Newman brought me today are proof of his incarceration regarding the failure to appear, but since it appears that we're not charging the failure to appear separately, there's nothing, just want to confirm there's nothing to null cross, or I don't need to turn these documents in to anyone. Is that correct?
I don't have an FTA on the calendar. Is there an FTA holding him?
Well, this is the charge that was holding him in jail, the FTA, just so abundant of caution. I would submit a FTA, no cost on that number that's listed on the calendar.
Thank you.
20-004660 FTA, just to abundant of caution.
Thank you.
Okay.
I can't see his booking screen, so I don't know what has been posted, but he was picked on the FTA.
Thank you.
Anything further, Ms. Vigilante?
Nope, that's it. Mr. Newman has been living at a residential treatment program for 9 months. He's doing great. He's ready to get out and get back to that.
Okay, Mr. Newman, it's my understanding that in case 23 CR 001434F, you wish to plead guilty to giving false information to law enforcement. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated, Mr. Newman. Good luck to you, sir.
Thank you, sir.
Thank you.
Thank you, Judge.
So I'm gonna leave you tomorrow,
Yeah. 24 to 48 hours to process bail, but that's, there's nothing else.
huh? All right, thank you.
Thank you,
Okay,
Judge.
who do we have in medical?
Yeah.
You could go ahead and do the jail iPhone.
No, I just wanted to know who we have so that I can.
Oh, I'm sorry. This is, position number 11, gas.
Okay. And so you've already spoken with him?
Mr. McLean, yes.
Okay, all right, thank you.
Yeah, we're in. Your Honor, Mr. Askew, number one on the calendar position is negotiated, please.
Okay.
Yeah.
And is it Askew Rice?
It's
Yes.
Anthony Askew.
Right.
Oh, I'm sorry, looking up at the screen, I'm sure.
Okay,
Jail court side phone.
yes, good morning, sir. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah.
Thank you. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can place your hand down. Yes, Mr. Rhodes.
Yes, Your Honor, as it relates to Mr. Askew Rice, I'll take it that the court has the criminal history. Since this is negotiated, I'll go straight to the recommendation, which
Okay.
as it relates to count one, simple battery is a 12 months probation offer. Count two is also 12 months probation, but to serve 66 days in jail, credit for the time he served since January 19th of 2024. We're asking that he have no further contact with Naomi Hairston and that he completes the Family Violence Intervention Program. He also completes 40 hours of community service, and that while on probation for this case, that he is to possess no firearms. Thank you, Your Honor.
Okay, and what is the calculation of how many days he served? Does anyone know?
Yes, Your Honor, it works out to being a 12-66-33 rectangular box that I always draw. It's actually been 33 days, I believe, today that he's been in custody because he's been given credit from January the 19th. That would be 13.
Okay,
Yeah, 13 days of January and 20 days of this month.
all right. Anything further, Mr. McLean?
Your Honor, I was so concerned about their phone dying that I want to just quickly note that I need an emergency contact to give to probation. If the deputy up there would just ask him for the emergency contact phone and mailing address, that would be greatly appreciated. He's ready to go forward.
Okay. Mr. Askew Rice, it's my understanding that in case 21 CR 002000D, you wish to plead guilty to simple battery and simple battery family violence. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, but I do have a question.
Okay.
He said that he was going to speak to you. I've been incarcerated since December 22nd, 2022. I was arrested in Daytona, Florida. I sat for a total of 28 days. I was extradited to Douglas.
It looks like we lost them. So
Your Honor, what he was about to ask, I had told him that the previous incarceration, he has been in continuous lack of freedom since 3 days before Christmas of the year 2022. Apparently twice during that time period, he had FTAs. I told him that we could easily prove and easily take care of with a little paperwork, getting rid of those FTAs because he would not have meant to miss court. I told him that didn't affect the calculation of the 66 and the 33, but the jail portion of the sentence is simply time served. The probation portion of the sentence of 10 months and 27 days would start today, and he'd have the certain requirements of FVIP, stay away, no contact. So he understood all that. He just wanted to talk about that time period, and unfortunately, sometimes people just want to talk too much about things that we've already covered.
Okay, well, guess we'll see if we can get him back before the end of the session. Who can we take next?
Hightower, Mr. Hightower.
What position is that?
16.
And what are we doing with Mr. Hightower today?
Negotiated plea.
Okay. Yes, good morning, Mr. Hightower. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video? Mr. Hightower?
No.
Got to speak up louder, Mr. Hightower.
Yeah.
Okay. Can you raise your right hand for me? Okay. It looks like Mr. Hightower is having some difficulty understanding.
Come back another day, Mr. Hightower.
What are you doing now?
Okay, well, you need to speak up for the court. And if you have any lack of understanding, let
You
us
see my
know.
hand?
Yeah.
Get my hand.
All right,
Okay, all right. I just want to make sure that you understand, Mr. Hightower. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I know, I understand.
Yeah, you do.
Okay, all right. You can put your hand down. Yes, Ms. Wolf.
Thank you, Judge. The offer in this case is 12 months served, 56 days, credit for time served of 28 days, balance suspended, and stay away from all MARTA.
Okay. Mr. McLean?
For the purposes of this plea, we would like to stipulate to factual basis, identification, and venue, which is say jurisdiction. And we'd ask the court to accept that. He understands it's going to be time served and balance suspended.
Okay. Mr. Hightower, it's my understanding that in case 23 CR 001402A, you wish to plead guilty to criminal trespass. Is that right?
Yeah, right.
Are you under the influence of any drugs or alcohol?
No, sir.
You've been represented by Mr. McLean. Are you satisfied with what he's done for you?
Yes, sir.
Do you understand that you have a right to a trial by jury on this charge? And because you're pleading guilty, you're giving up that right?
Yes, sir.
Has anybody forced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated. Good luck to you, Mr. Hightower.
All right.
Good to meet you.
Okay, let's go back to position one, Mr. Askew Rice, who's back with us. Mr. Askew Rice, we've had an opportunity to discuss your matter while you were getting back with us. It's my understanding that Mr. McLean has also discussed that with you. This is a time served plea as far as the 33 days that you will be given credit for. If you have any other questions, I'm happy to let you speak with Mr. McLean regarding that, but there's really nothing that the court can do in that regard. But if you want to speak back with Mr. McLean, I'm happy to give you that opportunity.
Yes, can I speak back with Mr. McLean?
Okay. So do we have anybody else that we can we go to medical and take that case first? Mr. McLean, that's your case?
Which person is that? Medical?
That's your,
Position 11, I think.
Yes, position number 11.
yeah, yes.
And that's QUE at the end of his name, GASQUE?
That's correct.
I believe it's pronounced Gask. He is a negotiated plea, Your Honor. He's ready.
Okay, good morning, Mr.
We spoke
Mr.
yesterday.
Good morning, Mr. Gask. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. Thank you, sir. Yes, Mr. Rhodes.
Yes, Your Honor, very briefly, I'll trust that Your Honor already has a good grasp of the criminal history since this is a negotiated plea. It's showing a total of 20 cycles, the bulk being out of South Carolina. As it relates to this case, the recommendation of the state is for 12 months, served 46 days, credit for time served of 23 days as of January 29, 2024. The balance is to be probated. We're asking that Mr. Gask stay away from South State Bank, which is located at 4600 Roswell Road, and that he's to have no further contact with the victim in this case, Mr. Cameron O'Day. Your Honor, we are asking that the court holds open the issue of restitution for 30 days. In this particular case, it is alleged that Mr. Gask went into the bank to cash a check that was fraudulent in the amount of $2,160.33. But before that attempt could be made, that he left the bank with the cell phone of Mr. Cameron O'Day, and that is the subject of the restitution, the cell phone of Mr. O'Day. And so we're asking that you hold open the restitution issue for 30 days so that we could resolve that.
Mr. McClain?
So there wouldn't be any other special conditions that would cause this to be anything other than balance suspended if, excuse me, other than that restitution. So I did have a question mark after the letter B. I usually put BS or BP, and this is B question mark as to that. Your Honor, I'm sure he will do his best to stay away from the individual name. If he simply saw a cell phone and picked it up, he may not have even known what the person looks like who belonged to that cell phone, or who that cell phone belonged to, rather. And he asked the court to accept his negotiated plea.
Okay, so what I think, so Mr. Rhodes, what I think I'll do is I think that I will place him on probation at least for 30 days. If he, within that 30 days, if restitution is requested, then he will be on probation until the restitution is paid. If within 30 days restitution is not requested, then the probation will terminate. How's that sound?
Your Honor, just out of precaution, we'll ask that you place him on probation for 60 days. I do agree with the suspension of the sentence after the actual restitution matter is handled. Just for clarity, Your Honor, the representative, Mr. Cameron O'Day, was the actual bank representative that was assisting Mr. Gask in this particular case. So I have no worries that he would in fact stay away from him. I just want to make sure that we nail that down. But I do agree that if we come back and report even before that 30 days that there is no restitution, maybe it's a deposit on, just a minor deposit on a whatever they do with cell phones, $100 deposit, a $200 deposit. And if that can be taken care of, we don't have any issue with the suspension of the sentence. We just ask for 60 days out of precaution.
Mr. McClain?
That sounds very logical. I would ask the court to consider waiving 1 or 2 months of the $49 probation supervision fee.
Okay, I'll waive the first month. Okay, anything further? Yep, Ms. Lewis, yes.
Yes, we got a problem. Probation, Ms. Thomas, are you on the line? Ms. Thomas,
Yes, I am. I'm sorry.
did you understand what they just said about the restitution? Because I'm trying to figure out, who they're gonna get the information back to, who's the restitution supposed to go to. I have no clue about the information right now. And well, who's gonna let probation know within 30 to 60 days if there is gonna be any restitution, and how you gonna let him know that what the amount's gonna be?
The state would inform me, and then if we don't, we would either agree right off the bat and look at it and say we consent to that amount, or we would say, let's have a hearing.
Not making my job.
The majority of times, in my experience through the years, the majority of time, it is a suitable amount, and the parties usually agree.
It'll either be the diminished value of the cell phone or whatever the victim, Mr. Cameron O'Day, paid in whatever he paid as a I keep saying deductible, but you guys know what I'm talking about. Whenever you have insurance on cell phones.
Right, it's it's kind of like a deductible on insurance. That's what it really is.
Yeah, so that's what it would be. But the victim is Cameron O'Day, Ms. Lewis. That would be the person that the restitution would go to. And we just need to verify either the diminished value of the cell phone or whether or not he had a deductible to pay to actually restore the phone.
Okay, I guess, can you just email me his contact and information, and I'll just put a note to probation. I just want to put probation on aware of when he reports to probation of what he has to do. And, you know, I just didn't want no confusion, because it is kind of confusing on my end, writing it up and trying to explain. So I just try to make it plain as possible.
So what we're saying is the lawyer is gonna contact us? Or, I mean, with the fine, or he's gonna send you the fine?
It's not a fine, it's a
Yeah,
restitution
fine, but the
amount.
restitution, I'm sorry.
Yeah, it's a restitution amount, and apparently they're giving them 60 days to determine the amount that he's supposed to pay, and if there's going to be anything to pay. So I guess I just want to put y'all on hold. I mean, let y'all be aware of the situation, so it won't be no confusion when he reports to probation and what he has to do.
So the only time that it will be reported is once we have the restitution in front of us. We can't just put restitution and have no restitution amount, because the person might come in and want to pay it within those 30 days and we don't have it. So we can't put it in the system until we have it, the full amount and the person's, the victim's information.
I don't know. I'm sure that McLean could probably agree with me, but we've had several situations where we've taken pleas where the restitution was to be determined. My guess is that within a week or so, if we either going to be able to find Mr. Cameron O'Day to confirm the restitution, or we will not be able to. And to that end, we will both be contacting probation as well as Ms. Lewis to say, hey, there is no restitution in this case. It can be suspended, the sentence can be suspended, or this is the amount of the restitution. And Mr. McLean could then advise as to whether or not he and his client would agree to the restitution, or whether they're requesting a restitution hearing. Is that your understanding, Mr. McLean?
Yes.
Okay.
Okay, well, that would be the first, so I thank y'all.
Thank you. All right, anything further?
Nothing further, Your Honor.
Nothing, Your Honor. I'll work very diligently to get this done, this restitution matter done by this week.
Thank you, Mr. Rhodes. Let's see, Mr. Gask, it's my understanding that in case 24 CR 000530, you wish to plead guilty to theft by taking, is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with your counsel's representation?
Yes, sir.
You understand you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept the plea as negotiated with the terms that we discussed. Good luck to you, Mr. Gasky. All right. Is there anyone else that we are able to take? And who do we have, medical?
This is position number one. We had to move down to the to medical because the phone died.
Oh, okay. And so there's no one else with you in there in courtroom 2, Mr. McLean?
No, Your Honor.
So I'm going to place you into a breakout room with Mr. Askew Rice so that you can discuss whatever concerns he has, okay?
Well,
Right.
all I wanted to ask him, Your Honor, was we discussed me taking this plea today was to kill the FTAs that are holding me.
Well, this is probably okay for open discussion. Let me be brief, though. If you have failed to make some court date from December 22nd forward, as you take this plea, there will be a general acceptance of your sincerity and the accuracy of your memory of dates. And I think the prosecutor would probably say, if it was one of our courts that you missed, we'll forgive it with a null cross. If it was some superior court or some other court that you missed, they can't do anything about it. You're going to have to get your certified paperwork out of your property bin and send that information to the court you missed. But if it was state court of Fulton County or magistrate court of Fulton County criminal division, we can take care of it right here and now. As you do this plea, that is our normal practice.
Okay, so the two that we discussed was the simple battery and a battery, correct? Or battery family violence.
You have one count of SBFB, which stands for simple battery family violence. Pleading guilty to that triggers the requirement for the SBIP course taking. You have a count simple battery that is not involved in simple family violence, and that is simply both misdemeanors. Neither one is called battery family violence, which is a felony the second time, so you don't have to worry about that kind of triggering. But you have one count of simple battery, one count of simple battery family violence. Both are alleged to have occurred on January 27th of the year 2021, which was several years ago.
And these are the FTAs.
The FTAs would have occurred on whatever court date was set since December 22nd, 2022, when you went to the Daytona jail and then got extradited to the Douglas County, Georgia jail.
Yes.
From 3 days before Christmas in the year 2022, if you missed any court dates, if it was our court, they'll forgive it. If it was somebody else's court, you're gonna have to prove it to that judge.
Okay, yes, sir.
Okay.
Okay, are we ready to continue with the plea?
Yes, Your Honor.
Yes.
Okay, so let me start from the beginning, and you are still under oath, Mr. Askew Rice. It's my understanding that in case 21 CR 002000D, you wish to plead guilty to simple battery and simple battery family violence. Is that correct?
Two pleas.
One plea.
One plea, 2 counts. Simple battery and simple battery family violence. It doesn't appear that he understands, Mr. McLean. I would be more comfortable if you had additional time to speak with him.
What's holding me here? Yes. That's what's holding me here. Yes.
Okay, so you do wish to plead guilty to simple battery and simple battery family violence. Is that correct?
Yes, Your Honor. Yes.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir. No, Your Honor.
You've been represented by counsel. Are you satisfied with his representation?
Yes, Your Honor.
You understand that you have a right to a trial by jury on these charges, and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Askew Rice. Good luck to you, sir.
All right.
Is there a hyphen in Askew Rice? That's one last name, but 2 words. Is there a hyphen or not?
It's a hyphen. Askew Rice.
Thank you.
So I'll be released today.
If nothing else is holding you, and if we find out that you do have FTAs that you are fearful of, and if those FTAs involve our court, I think that they can rapidly take care of that for you. But if you have a hold somewhere for an FTA in a court in some other county, or if it's in Superior Court of Fulton County, we can't help you on that. Our lawyers will help you on that if it's in Fulton County, Superior Court, for example. We have lawyers that operate in that division as well.
No, I don't have any holds. I was brung from prison to this jail on these FTAs. These FTAs are stopping me from being released. That's the only thing.
Is anyone in this room aware of any FTAs that are holding him?
I just think the message that there appears to be a hold out of Georgetown, Ohio, so he's held without bond as a fugitive from justice out of Georgetown, Ohio. I don't know the nature of the case, but it's showing on his jailing screen, there are 2 holds. And one is
Do you need my social security number? Do you need my social security? I've never been to Georgetown, Ohio. I'm not him.
Okay, that's an extradition matter that you can handle in another hearing. But what else besides Georgetown, Ohio, does it look like?
The other one I can't make out is these travelers and then stop at rest.
Do you need my social security number, sir?
Jail's got it.
I've never been in trouble in Georgetown, Ohio. I don't have any holds. I came from prison to this jail. I can tell you exactly how they bring me here, what jails they housed me at for 1 day. On the 18th of January, I was released from prison, held in Coffee County Jail down in I forget what part of Georgia that was, and extradited up here.
Ironically,
yeah, Mr. McLean, if there is a hold, work with him to see if there is or is not a hold in the matter. Okay. Ms. Tyson, did you have something that you wanted to inform the court of?
I don't see it on the jailing screen, but I know that's probably just a function of not being, being able to do things with the system. But I know on his GCIC, it looks like there's some old warrants. I don't know and I'm not sure, one from Philadelphia, another one out of East Point.
Non-extradition from
And then,
Philadelphia.
and just the FTA that you guys were talking about. But those warrants, the Philadelphia warrant was from 2014, and then the East Point one is from 2021. But I know on the jailing screen, it doesn't show anything right now. But like I said, that could just be a function of us not being able to have full access.
According to what I can find and bring up, he doesn't have no holds or nothing. This case is only thing holding him in there. He does have a rearrest on a simple assault case with a 22 CR 003-957D, which I am trying to look up to find out what was the result of that case and why this case was not on the counter, if it has been resolved or not. That's it. Other than that, he doesn't have no other hold. And apparently that is the other FTA that he's talking about. I see it right now. There was another case that was signed to Judge Edline. The case number is 22 CR 003957D as in Delta, which is a simple assault family violence that happened March the 22nd of 2021. And that case was about a bench warrant. Failed to appear, and that is on his name. So we only settled the case that's on the counter today, and he still has the charge I just mentioned still open. So I don't know why that didn't make it on the counter. That's another file forfeiture. So all I can do is just pull that file folder and place that case back on the counter for Thursday, unless they can do a global resolution on the case. Now I don't know if the ASG is aware of that open case or not.
It's in Brown County, Ohio.
Okay, let's place him back. I want this resolved, so let's place him back on the calendar for Thursday.
I'll put back on Thursday for the case for the 22 CR 003957D, the incident that happened on March the 22nd of 2021 of simple assault family violence. That's the only thing that will be left on his record at Fulton County Jail. The case that we dealt with today is resolved, but he's correct. This is the only FTA.
All right, so we'll get that resolved and we'll get that other case back on the calendar. Okay, so we'll see you back on Thursday to make sure that we have everything resolved. Mr. Askew Rice.
Okay, all right.
All right, thank you for. All right. Is there anyone else that we can take, or is that all that we have today?
All I've got.
Okay,
I think
so,
that's it.
well, someone's coming in. Let's see who this is.
No, I'm sorry, we were gonna, Officer Blunt, she's going to get, Mr. Sims.
Sorry.
Okay. Well, she couldn't find Mr. Sims, Calvin Sims.
Okay.
Okay. So you found Mr. Sims?
No, he could not be found.
Okay, all right. So is there anyone that we have that has been found? Are we done?
Well, that completes my list. We don't have anybody else.
Okay, so we will have to, anyone that we did not take, and that we will have to reschedule them as we have previously discussed, Ms. Lewis, as we go through the calendar.
Yes, Your Honor, when we go to the counter, we'll indicate if they're gonna reset to Tuesday or Thursday.
Okay, thank you. And I think that if we don't have anyone else, whenever you're ready, we can go through the calendar.
Okay, I'm ready. All right. Let's start with the probation calendar. For Ashley Harvey, that case is gonna be reset further notice before Judge Porter at a later date. On the add-on calendar, position number 1, Johnson, is a time served plea. Position number 2 is gonna be reset for Thursday, SAP. Defendant is not represented by the attorney that's on record. She was only represented for the first appearance calendar.
Which one is that? Tate?
Yeah.
Oh, all right.
Everybody on accord with that?
Yep.
Okay, all right. We're back to the regular calendar. Position number 1, took a plea. We're gonna add his, other outstanding case number 22CR 003957D as in Delta on Thursday counter. Position number 2 was a non-negotiated plea. Position number 3, 4, and 5, defendant waiver arraignment, not guilty, cases reset for trial further notice. So I will be expecting a waiver arraignment from you, Mr. McLean.
Very good.
Position number 6, apparently was not able to be located. It looked like it's going to be a time served plea, so he'll be replaced back on Thursday calendar. And that date for Thursday is February the 22nd. And that'll be the SAP for Thursday. Position number 7. Position number 7 was a non-negotiated plea. Position number 8 was a plea. Position number 9, it looks like he's gonna have extra time, so that's gonna be set for Tuesday. SAP, which that day is 2/27. Position number 10 was a plea. Position number 11 was a plea. Position number 12 was a plea. Position number 13.
There was a notation on 13 that the state wanted to add a different case in addition on Thursday, the 22nd.
Need to add an additional case, so.
The case they wanted to add was 24CR 000421H.
Is that gonna be a time served plea also?
I do not know.
So do we need just going to add them on to Thursday counter or Tuesday?
Yeah, let's just go ahead and add them on Thursday.
Okay, Thursday add-on. Position number 14 was a plea. Position number 15 Then it was not located.
Position 14 was is sort of two pleas.
That's correct. He took a plea on the cases on the counter and the one that was not listed, which is 24 CR 00422J also. I'll make that adjustment on the counter when I send it over to the jail. Let's see here. Position number 15.
Herbert was not seen.
Excuse me?
I don't think we saw Mr. Herbert today.
No, and I don't know what Mr. Herbert is. Looks like he got fines to pay. Can we set him for Tuesday?
No, he's gonna get out of jail, so anybody's gonna get out of jail, let's give him.
I can't, it said 12 months to serve 24 hours, credit for time served 24 hours. I don't, and he has all this restitution, fines to pay, so. All right, Thursday, I'm assuming, if he takes, so that's Thursday. Just remember, you guys got a whole bunch of cases for Thursday.
And we had a whole bunch today too, so we're getting it, so.
Okay.
I'll move them through.
I'm moving through, Judge. I'm moving through. Position number 16 is a plea. Position number 17. That look up for Tuesday. SAP. It looks like he has extra time.
It's only 6 days of extra time that the state is asking for in the recommendation they would like to offer him. But we haven't met Mr. Holloway. He was not found yesterday.
Well, that's close enough. Next Tuesday.
Okay, thank you, Judge.
The date, the 27th.
Yes, that day will be the 27th. That's correct. Position number 18. That's Tuesday. SAP. Position number 19. That's Thursday. SAP. Position number 20.
Cassandra Kelly?
Yeah, that's Kelly. It looks like it's like all these are time served. Thursday. Position 21 was a plea. Position 22. It looks like it's Thursday. SAP. Position 23. It looked like Tuesday. SAP. Position 24 was a plea. Position 25, the bond was amended to a $4,000 SOB through pretrial level 1. That's reset for the notice for trial, and I'm expecting a waiver or arraignment on that case also.
Yes, ma'am.
Thank you. Position number 26 is reset to add-on count for Thursday, February 22nd, SAP.
Excuse me, Ms. Louis, I may be.
I couldn't hear you. What'd you say, Mr.
There's an echo. I was asking.
I hear you, but I can't hear you. It's like.
Right, we can't.
Judge, check the chat. We can.
Oh.
Oh, thank you.
Okay. All right.
Oh, yes, that's fine. Yes. Have a good afternoon.
Position number 27 is reset for the SAP for Tuesday, I'm sorry. That's Mr. McLeod's case. Position number 28 and 29. You were still trying to if you still at Grady, so you do want to hold on to Tuesday? PD?
Yeah, let's put him on for next Tuesday.
Thank you.
And Miss Vigilante was gonna check and with Grady and see if we can locate Mr. Pascal.
Yeah.
Okay. Position number 30 was a plea. Position 31 was a plea. Position 32. We're holding off the that's gonna be on Tuesday counter till we get verification that the case is gonna be transferred to the DA. Position 33 was a plea. Position, we just heard about position 34 and 35. That's gonna be Tuesday. Is that
Great.
Tuesday? Position 34 and 35, Tuesday, SAP.
What did you say about position number 34, Kevin Sims?
34 is Kevin Sims, set to the SAP for Tuesday, and also position 35 is gonna be reset to Tuesday. That's Charles Smith. So there's no recommendation. Position 36. That's gonna be reset to Tuesday. Yeah, extra time. 37 was a plea. 38, the bond was amended to a $500 SOB through pretrial. And a waiver of arraignment, not guilty.
5,000.
It's 5,000. I thought you said 500. That's what we had. So it's 5,000.
Yes, Ms. Lewis,
Yes.
5,000.
But it's through pretrial still.
Ms. Lewis, would you like me to, because I did edit it to 500.
I saw it. I'll take the one that you, I'll make that adjustment.
Thank
you.
Thank you.
I saw it. And I think that takes care of the counters. Any questions or concern? All the paperwork come to me in a timely manner, please. And I think that's it. Anybody got any questions or concerns or anything?
All right. Thank you all for your patience today.
Thank you, Judge.
Yes, we'll see you next time. And,
All right, Mr. McLean, are you coming to my office to drop off the paperwork, or are you going to email it to me?
You want me to cough on you or do you want me to email it?
It's up to you, sir. Whatever your preference is. If you
I've got
drop
my
it off-
lozenges. I'm gonna flip the coin. I got my lozenges.
Okay, whatever you decide, it'll work with me.
Thank you.
Okay, I appreciate y'all today. Thank you.